Everyone knew him as the tech mogul who built the world's largest social media empire. But when Mark Zuckerberg stood up in federal court that day, he was about to reveal a secret he had kept hidden since his Harvard days. Not just computer science genius, but deep constitutional law expertise, years of studying digital rights and technology regulation, mastery of First Amendment jurisprudence in the digital age. Judge Brett Kavanaugh was dismissing him as just another tech CEO trying to avoid regulation, unaware that standing before him was someone who understood constitutional technology law better than most Supreme Court clerks. Zuckerberg's first legal argument alone would completely transform the courtroom atmosphere. "Your Honor, Judge Kavanaugh," said Zuckerberg, his voice carrying the same precision that had built Facebook into a global phenomenon. "May I speak to you about the First Amendment's application to digital platforms and the constitutional limits on government content regulation?" What happened that day in the San Francisco federal courthouse would revolutionize both technology law and constitutional interpretation for the digital age. Before diving into this extraordinary legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected constitutional brilliance challenging established legal thinking. Kavanaugh's world. Traditional constitutional authority. Judge Brett Michael Kavanaugh represented the established conservative legal order. At 59, the former Supreme Court justice had built his reputation on originalist constitutional interpretation and skepticism toward expansive readings of digital age rights. A Yale Law School graduate who had served as a White House staff secretary and D.C. Circuit judge, Kavanaugh embodied traditional judicial conservatism. His judicial philosophy emphasized textual interpretation of constitutional provisions written centuries before digital technology existed. This approach made him resistant to arguments that constitutional principles should evolve to address technological innovations the framers never anticipated. Kavanaugh particularly distrusted technology companies, viewing them as monopolistic entities that used free speech arguments to avoid legitimate government regulation. He saw tech executives as businessmen who deployed constitutional rhetoric to protect commercial interests rather than genuine advocates for digital rights. That day, his assumptions about Mark Zuckerberg were predictable. Yes, Zuckerberg had built an innovative company. Yes, he had become extraordinarily wealthy, but in Kavanaugh's view, he was simply another CEO trying to use constitutional arguments to escape regulatory oversight. This assessment would prove to be profoundly mistaken. Zuckerberg's hidden journey from code to constitutional law. The world knew Mark Zuckerberg through his technological achievements, from his Harvard dorm room creation of Facebook to building a global platform connecting billions of users. His story had become legendary in Silicon Valley and beyond. With a net worth exceeding $100 billion, he stood among the most powerful people on earth. But what the public didn't know was that Zuckerberg's interest in technology had always been intertwined with deeper questions about communication, democracy, and constitutional governance. Starting in 2010, as Facebook faced increasing government scrutiny, Zuckerberg had begun intensive study of constitutional law, particularly First Amendment protections for digital expression. Technology is reshaping how people communicate and organize politically, he had told his longtime COO, Sheryl Sandberg, during one of their strategic planning sessions. "If we're going to protect digital rights, I need to understand the constitutional framework that governs free expression." Working with constitutional law professors from Stanford and Harvard, Zuckerberg spent his limited free time studying Supreme Court precedents, First Amendment theory, and the historical development of free speech protections. He completed advanced coursework in constitutional interpretation, digital rights law, and the intersection of technology with democratic governance. By 2023, when the case that would bring him to federal court emerged, Zuckerberg wasn't just defending his company's business interests. He was also a well-educated advocate for digital constitutional rights, with genuine expertise in the areas of law that governed online expression. The Case Foundation. Digital speech versus government control. The federal case that brought Mark Zuckerberg before Judge Kavanaugh represented one of the most significant First Amendment challenges of the digital age. Meta Platforms, Inc. v. Federal Trade Commission challenged new government regulations requiring social media platforms to remove content deemed harmful to democratic discourse as violations of both the First Amendment and due process protections. The regulations had emerged from bipartisan congressional concern about misinformation and extremist content on social media platforms. The FTC's new rules required platforms to implement government-approved content moderation systems and remove posts that federal regulators determined violated new democratic discourse standards. The case had massive implications for digital rights and constitutional law. If the government's position prevailed, it would establish that federal agencies could regulate online speech based on content and viewpoint, a fundamental departure from traditional First Amendment protections. If Zuckerberg won, it would create new precedents protecting digital expression from government censorship. For Kavanaugh, this case represented an opportunity to assert legitimate government regulatory authority over powerful technology companies while maintaining traditional constitutional limits. He viewed it as a matter of balancing free speech with democratic governance and corporate responsibility. For Zuckerberg, the case was about fundamental constitutional principles that extended far beyond his company's interests. Whether the First Amendment would protect digital communication in the same way it protected traditional forms of expression, and whether the government could use content-based regulations to control online discourse. The setting: San Francisco Federal District Court. The modern courtroom of the U.S. District Court for the Northern District of California buzzed with unprecedented media attention. This case had drawn constitutional law scholars, digital rights advocates, technology industry leaders, and government officials from across the country. At the plaintiff's table sat Mark Zuckerberg, dressed in a sharp navy suit that projected seriousness rather than Silicon Valley casualness. His legal team from Gibson Dunn and the Electronic Frontier Foundation flanked him, though Zuckerberg had insisted on presenting key constitutional arguments himself, a decision that had surprised legal observers. At the defense table, the Federal Trade Commission had assembled their top constitutional lawyers, led by Deputy General Counsel Sarah Martinez, a former Supreme Court clerk with extensive experience in First Amendment litigation. Behind her sat federal regulators and Justice Department representatives, all confident this would establish important precedents for government oversight of digital platforms. Judge Kavanaugh, presiding over this case due to its constitutional significance and potential impact on digital rights jurisprudence, had already expressed skepticism about technology companies' constitutional claims through his previous rulings. First contact: the dismissive challenge. Mr. Zuckerberg, Judge Kavanaugh began, his voice carrying the authority of decades in federal courts. This court recognizes your commercial success in the technology sector. However, First Amendment law involves complex constitutional principles and sophisticated governmental interest analysis. Are you prepared to engage seriously with constitutional doctrine rather than simply asserting business preferences? The question was designed to highlight what Kavanaugh saw as the fundamental mismatch between business leadership and serious constitutional scholarship. His tone suggested he expected Zuckerberg to rely on his professional legal team or demonstrate the kind of constitutional superficiality he associated with corporate constitutional litigation. Zuckerberg stood deliberately, his posture respectful but confident. "Your Honor, I understand your concern about my background. However, I'd like to address your question by discussing the Supreme Court's evolution in First Amendment jurisprudence from Schenck v. United States to Brandenburg v. Ohio, and how those precedents apply to government regulation of digital expression." A surprised murmur rippled through the courtroom. This wasn't the corporate legal rhetoric Kavanaugh had expected. The court's movement from the clear and present danger test to the Brandenburg standard, Zuckerberg continued, reflects a fundamental constitutional principle. The government cannot regulate speech based on its content or viewpoint unless that speech is directed to inciting imminent lawless action and is likely to produce such action. Kavanaugh's expression shifted slightly. The response demonstrated actual understanding of First Amendment doctrine, not just business talking points. Testing the constitutional waters. Mr. Zuckerberg, Kavanaugh continued, his tone becoming more serious. Citing landmark cases is one thing. Understanding how contemporary First Amendment analysis balances free speech against legitimate governmental interests is quite another. Are you familiar with how modern courts evaluate content-based speech regulations? This was the kind of question designed to separate constitutional amateurs from serious First Amendment scholars. Zuckerberg nodded confidently. Absolutely, Your Honor. The court's contemporary First Amendment framework, established in cases like Reed v. Town of Gilbert and refined in decisions like Iancu v. Brunetti, requires strict scrutiny for any government regulation that is content-based or viewpoint discriminatory. Kavanaugh leaned forward, his interest clearly piqued. Continue. Under strict scrutiny, Zuckerberg proceeded, the government must demonstrate that its regulation serves a compelling governmental interest and is narrowly tailored to achieve that interest through the least restrictive means possible. The FTC's regulations fail this test because they are both content-based and viewpoint discriminatory, and the government has less restrictive alternatives available. The courtroom had grown quiet. Legal reporters were taking detailed notes, and even the government's attorneys were paying close attention to this unexpected constitutional analysis. The revelation: Zuckerberg's constitutional expertise. Mr. Zuckerberg, Kavanaugh said, his tone now markedly different from his initial dismissiveness. Your First Amendment analysis demonstrates considerable constitutional sophistication. Where did you develop this expertise in digital rights and constitutional law? Zuckerberg's response would reveal the depth of his constitutional preparation. Your Honor, I've spent over a decade engaged in intensive study of First Amendment law and digital constitutional rights, initially through Stanford Law's Executive Education Program, later through private study with constitutional scholars specializing in technology law and free expression. I've worked directly with Professor Pamela Karlan at Stanford on First Amendment theory, studied under Professor Genevieve Laker at University of Chicago on digital speech rights, and completed advanced coursework through Harvard's Constitutional Law program, focusing specifically on the intersection of technology, democracy, and constitutional governance. The courtroom buzzed with surprise. Kavanaugh himself looked genuinely taken aback. Moreover, Zuckerberg continued, my practical experience building platforms for global communication has given me unique insight into how constitutional principles apply to digital expression. I've seen firsthand how government content regulations can chill protected speech and undermine democratic discourse. Kavanaugh's deeper constitutional challenge. Kavanaugh, now taking Zuckerberg's argument seriously, decided to test the deepest level of his constitutional understanding. Mr. Zuckerberg, your case essentially argues that digital platforms deserve First Amendment protection equivalent to traditional media. But how do you address the argument that social media companies are private entities whose content moderation doesn't constitute state action subject to constitutional constraints? This question went to the heart of modern constitutional law, the sophisticated state action doctrine that typically separated legal generalists from serious constitutional scholars. Zuckerberg's answer would demonstrate whether he truly understood the complexities of constitutional law in the digital context. Your Honor, there's an important distinction between our content moderation decisions, which are private editorial choices protected by the First Amendment, and government regulations that compel or prohibit specific content moderation practices, which constitute state action subject to constitutional scrutiny. He paused to organize his constitutional argument. The Supreme Court's decision in Miami Herald Publishing Co. v. Tornillo established that the government cannot compel publishers to include specific content, even to serve fairness or democratic discourse goals. This principle applies even more strongly to digital platforms, which face exponentially more government pressure to moderate content in government-preferred ways. Kavanaugh was now fully engaged with Zuckerberg's constitutional analysis. You're arguing that government content moderation requirements constitute compelled speech? I'm arguing something broader, Your Honor, The FTC's regulations create a comprehensive government censorship scheme disguised as content moderation requirements, Zuckerberg responded. When the government defines harmful to democratic discourse and requires platforms to remove such content, it's engaging in viewpoint discrimination that violates core First Amendment principles. The precedent analysis, building digital constitutional framework. Moreover, Zuckerberg continued, we have direct precedent for protecting digital expression from government censorship. The Supreme Court's decision in Reno vs. ACLU specifically held that the Internet deserves the highest protection under the First Amendment, and that government attempts to regulate online content based on its communicative impact violate constitutional principles. Kavanaugh was taking careful notes. How does Reno apply to contemporary content moderation regulations? Reno's constitutional principle applies even more strongly today, Zuckerberg replied. The court emphasized that the Internet's democratic potential depends on protecting diverse voices and perspectives from government censorship. The FTC's regulations operate exactly like the Communications Decency Act that Reno struck down. They empower government officials to determine which online expression serves democratic discourse and which doesn't. Zuckerberg then presented his most sophisticated constitutional argument. The court's recent decision in Manhattan Community Access, Corp. v. Halleck, confirms that when government regulations control private editorial decisions, they transform private platforms into state actors subject to First Amendment constraints. The FTC's regulations do exactly that. They substitute government editorial judgment for private editorial discretion. Kavanaugh's constitutional recognition. The change in Judge Kavanaugh was evident to everyone in the courtroom. His initial skepticism had evolved into genuine engagement with Zuckerberg's constitutional arguments. Mr. Zuckerberg, Kavanaugh said, I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented First Amendment arguments that merit serious consideration from this court. Thank you, Your Honor, Zuckerberg responded. I hope this demonstrates that constitutional principles transcend traditional professional boundaries. When fundamental rights are threatened, advocates can emerge from any background, including technology. Kavanaugh nodded thoughtfully. Your argument essentially contends that government content moderation requirements violate both the free speech rights of platforms and the free speech rights of users. This raises complex questions about the boundaries of government regulatory authority. The government's Constitutional Defense Deputy General Counsel Martinez, representing the FTC, attempted to refocus the constitutional conversation. Your Honor, while Mr. Zuckerberg's constitutional studies are noteworthy, the fundamental issue remains democratic governance. The government has legitimate authority to prevent online platforms from undermining democratic institutions through harmful content. Kavanaugh turned to Martinez with new interest in the constitutional balance. Counselor, how does the government respond to Mr. Zuckerberg's argument that content-based speech regulations require strict scrutiny regardless of the platform involved? Martinez found herself defending government speech regulations against sophisticated constitutional arguments rather than dismissing corporate legal theater. Your Honor, social media platforms operate as public forums that affect democratic discourse. The government's interest in preserving democratic integrity justifies reasonable content regulations. Zuckerberg was prepared for this constitutional response. Your Honor, the government's public forum argument actually supports our position. In cases like Rosenberger v. University of Virginia, this court held that when government treats private entities as public forums, it cannot engage in viewpoint discrimination. The FTC's regulations explicitly discriminate based on viewpoint by defining certain political perspectives as harmful to democratic discourse. Constitutional framework development. Zuckerberg then presented his proposed constitutional solution. I suggest a framework that protects both digital expression and legitimate government interests. First, government regulations of online content must meet strict scrutiny when they're content-based or viewpoint discriminatory. Second, The government can address specific harms through narrow regulations that don't control editorial decision-making. Third, platforms retain First Amendment protection for their own editorial choices, while users retain First Amendment protection for their expression. Kavanaugh engaged directly with this constitutional framework. How would your proposed framework address legitimate government concerns about misinformation or extremist content? The framework protects government's ability to address specific illegal conduct, true threats, incitement to imminent violence, criminal conspiracy, Zuckerberg responded. But it prevents the government from regulating legal speech based on its content or democratic impact. The First Amendment requires this distinction because allowing the government to determine which lawful speech serves democratic discourse gives government officials censorship power that the Constitution specifically prohibits. Zuckerberg concluded with his strongest constitutional argument. The framers understood that democracy depends on protecting unpopular speech from government censorship. When the government regulates online expression to protect democratic discourse, it undermines the very democratic principles it claims to serve. Kavanaugh's final constitutional assessment. As the hearing concluded, Judge Kavanaugh addressed Zuckerberg directly. Mr. Zuckerberg, your constitutional arguments today have been remarkable. You've demonstrated understanding of First Amendment law and digital rights that rivals the most experienced Supreme Court advocates. Thank you, Your Honor. This case has never been about protecting Meta's business interests. It's been about ensuring that constitutional principles apply to digital communication with the same force they apply to traditional forms of expression. Kavanaugh reflected on the broader constitutional issues. Your arguments raise fundamental questions about the scope of government regulatory authority in the digital age. This court will examine them with the seriousness they deserve. The landmark Digital Rights Decision. 2 weeks later, Judge Kavanaugh issued a comprehensive 45-page decision that would reshape technology law and digital constitutional rights. The ruling found that the FTC's content moderation regulations violated both the First Amendment rights of platforms and users, establishing new precedent for constitutional protection of digital expression. More significantly, Kavanaugh's opinion adopted key elements of Zuckerberg's constitutional framework, creating new standards for how courts would evaluate government regulations of online content. The decision included an extraordinary judicial acknowledgment. This case demonstrates that constitutional expertise can emerge from practical experience with the technologies that are reshaping democratic communication. Mr. Zuckerberg's analysis has contributed meaningfully to this court's understanding of First Amendment protections in the digital age. Broader constitutional and industry impact. The Zuckerberg vs. FTC decision created immediate changes in federal technology policy and sparked national conversation about digital rights and government authority. Constitutional law scholars praise the decision as a landmark victory for First Amendment protections in the digital context. Law schools immediately began incorporating Zuckerberg's constitutional arguments into their technology law and First Amendment curricula. The case became required reading for constitutional law, digital rights, and technology policy courses nationwide. For the technology industry, the decision established crucial precedents protecting digital platforms from content-based government regulations while preserving platforms' own First Amendment rights to make editorial decisions. Personal and professional transformation. For Mark Zuckerberg, the case represented validation of years of constitutional study and commitment to digital rights principles. Legal scholars and digital rights advocates recognized him as a serious constitutional voice rather than simply a business leader defending commercial interests. Judge Kavanaugh later reflected on the case as a reminder about expertise and assumption in the digital age. The Zuckerberg case taught me that constitutional law must evolve to address new technologies, and that the people building those technologies often understand their constitutional implications better than traditional legal establishments. Long-term constitutional legacy. The constitutional precedents established in Zuckerberg vs. FTC influenced digital rights law for years afterward. The decision's framework for protecting online expression from government censorship became a model for courts addressing technology and constitutional law. Most importantly, the case demonstrated that constitutional expertise could emerge from technological innovation and that the most meaningful digital rights arguments often came from those who understood both technology and constitutional principles. Mark Zuckerberg had proven that true constitutional advocacy in the digital age requires combining technological understanding with rigorous legal scholarship, and that protecting digital rights demands the same constitutional courage that has always been necessary to defend fundamental freedoms. The case ultimately became more than a legal victory. It became a foundation for constitutional protection of digital expression and a reminder that constitutional law must adapt to protect fundamental rights in new technological contexts. If you found this incredible story of digital constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging established institutions. Ring that notification bell so you never miss these extraordinary stories of how constitutional knowledge and technological innovation can combine to protect fundamental rights. What did you think of Zuckerberg's constitutional expertise? Share your thoughts in the comments below.